Good morning. Are you Takarian Gilbo? Excuse me. And this is 21-36753. Ms. Gilbo is charged with unauthorized use of a vehicle. 2021.
Yeah.
What is the announcement?
If we could get one more reset, Your Honor. I have met with her. We have received an offer from the state. We just need to have some time to review, and we'll be prepared to do something.
Sure. I'm going to do a normal. Any issues?
No, Judge, and the other two co-defendants have been disposed of.
Okay. Thank you. I'm going to reset your case about 30 days or so. Make sure you call, make an appointment, visit with Ms. Holmes before that next court day. Okay.
Yes.
All right. Y'all free to go.
Knock on wood. It's was a deal.
All right, sir, are you Aaron Shetley?
Yes, ma'am.
Again, and so, Mr. Shetley, in cause number 24, DCCR 0776, you're charged with the third-degree felony offense of assault, family violence by impeding breath.
Buckle up, guys. Today we are stepping inside a courtroom where every second can change a life forever. Right from the opening, the judge lays out the harsh reality. This is not just procedure, this is about consequences that can take away years of freedom. The atmosphere feels heavy, almost suffocating, as the words echo with authority. This is where decisions are final, and excuses carry no weight. You can sense that what happens here will stay with these individuals for the rest of their lives. One wrong move, one wrong answer, and everything can collapse instantly. It's not just a hearing, it's a turning point. The stakes are real, and the pressure is undeniable.
From October 22nd of 2022. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here a plea bargain rejection that you've signed that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case.
Just a part, Judge. I didn't put a term.
Okay.
We did.
Deferred probation. Okay, so for deferred probation, which is, I'm sure you've talked with your attorney, is a type of probation where you don't have a felony conviction on your record if you successfully complete it. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty.
The session begins in a calm, almost routine manner, but even here, every detail matters. A simple request for a reset shows how the system works behind the scenes, lawyers negotiating, time being requested, and the judge carefully managing the flow. Nothing dramatic happens on the surface, yet these quiet moments carry hidden importance. This is where strategies are formed and decisions are delayed for the right reasons. It reflects how the legal system values preparation over haste. Even a small delay can impact the direction of a case. The judge's control keeps everything structured and fair. It's a reminder that not every critical moment is loud, some are silent but powerful.
And you want to reject that offer and have your case set for trial.
That's correct.
All right, we'll get it set for trial. Obviously, if something changes with any negotiation, y'all let me know as quickly as you can before trial. All right, thank you, sir. Stay in touch with us. Walker, he'll let you know when to come back.
Now the tension rises as the defendant is faced with a clear choice: accept a deal or risk everything at trial. The judge carefully explains the consequences, making sure there is no confusion. Yet despite the warning, the defendant rejects the offer. It's a bold move, one that instantly raises the stakes. From this point on, there's no easy way out. The safety of probation is gone, replaced by the uncertainty of trial. You can feel the weight of that decision in the room. It's a gamble with serious consequences. One path offers control, the other risk. And he has chosen the harder road.
The paperwork on that?
She was standing outside.
I think they called her name. I know they called her name.
Called her name?
Yeah.
Okay. All right.
No, her name was called, and I guess I can explain it to her in a minute.
Okay.
Yeah, just
All right.
give me just a second. Need a sentencing on to Timoteo Castaneda, please. Good morning, sir. Are you Timoteo Castaneda? And Mr. Castaneda was previously in court, entered a plea of guilty to indecency with a child by sexual contact. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. No additions or corrections.
Same Penn State, Your Honor.
All right. Any reason not to go forward with sentencing?
No, Your Honor.
No.
All right, sir. I'm going to find that you previously entered your plea of guilty freely and voluntarily. find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That will include being on the sex offender caseload and following through with any required treatment. They will also do a substance abuse assessment to see if there's any treatment needed for that. Whether you think you need it or not, if they say there's treatment needed, you will be ordered.
An attempt is made to slow things down as medical concerns are brought into the conversation. It's a human moment, showing vulnerability, but the courtroom remains grounded in reality. The judge listens, but does not allow the process to lose momentum. Justice cannot be paused indefinitely, no matter the situation. There is a balance between compassion and responsibility. This moment highlights that emotions alone cannot dictate outcomes. The law requires consistency and fairness above all. Even when circumstances are difficult, decisions must still be made. It's a reminder that the courtroom runs on facts, not feelings.
Recommendations. You're also to abstain from the use of all intoxicating substances, including alcohol. If there's any issues with your ability to do that, talk to probation and they'll get you the help that you need. Finally, in addition to the other regular conditions, you will have no contact at all with Saul Villalobos. That's obviously in person. That's through any other means. You can't send messages, electronic contact, anything like that. If you do everything that you're supposed to correctly on your probation, then this is a great opportunity, because at the end of your probation, the case will actually be dismissed and you won't have the felony conviction on your record. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you can.
The tone shifts sharply as a serious charge is brought forward, immediately changing the atmosphere in the room. A guilty plea is confirmed, and the weight of the offense becomes clear. This is no longer routine, it's a life-altering moment. The courtroom grows quieter as everyone understands the gravity of the situation. There's no argument, no hesitation, just acceptance. That alone speaks volumes. It shows that sometimes the evidence is overwhelming. The focus now turns from guilt to consequence. And what comes next will determine the future of the defendant.
Sentence anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yeah, it's fine.
You already signed and went over the sex offender registration requirements paperwork. It is very important that you keep up with that and make sure that you're registered appropriately at the right place, right time every year, okay? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you.
Thank you, Judge.
Let's, Janisha Jackson, Ms. French.
I'm signing it now, Your Honor. There was a glitch with the time.
Oh, I'm sorry. Let me, I'll hold that a minute because they'll have to do fingerprints and everything. Just have a seat. Watch for the clerk. She'll call you up in a minute. What about Autumn Payne?
In a surprising turn, the judge chooses probation instead of immediate prison time. It's a decision that offers a second chance, but not without strict conditions. The terms are detailed and serious, leaving no room for mistakes. This is not freedom, it's controlled opportunity. The defendant is given a chance to rebuild, but under constant supervision. Every action from this point forward will be monitored. The judge makes it clear that this is a privilege, not a right. It's a rare moment where accountability meets mercy. But the responsibility now lies entirely on the defendant.
Good morning. Are you Autumn Payne?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She did, Judge.
Ms. Payne, in cause number 25, DCCR 1142, you're charged with a state jail felony offense of criminal mischief from July 19th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement.
Yes.
The judge follows up with a strong and direct warning that cuts through the room. One violation, one mistake, and everything changes instantly. The possibility of prison is no longer distant, it's very real. The tone becomes firm, almost unyielding. This is where the true weight of probation is revealed. It's not an escape from punishment, but a test of discipline. The defendant must now prove they deserve the opportunity given. There are no second chances beyond this point. The message is clear: follow the rules, or face the consequences.
Looks like the agreement is for a 5-year deferred probation. There would be a $500 fine. There would be restitution ordered in the amount of $4,050, and you would be required to follow all of the rules and conditions of probation, including having no contact or communication at all with Anrith Scott. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Payne is not competent?
Nothing.
And based on the fact that it's a state jail and you have that restitution, is there any reason not to go forward with sentencing and waive that report?
Not at all, Judge. In fact, I was going to suggest that my records only show a 2021 arrest.
Another defendant steps forward, but this time there is no hesitation. The guilty plea comes quickly, almost without resistance. It's a stark contrast to earlier decisions. This moment reflects acceptance, perhaps even understanding of the situation. There's no attempt to fight or delay. Sometimes, facing reality becomes the only option left. The courtroom acknowledges this with efficiency. The process moves forward smoothly. It shows that not every case is a battle, some are about owning the outcome. And that alone can shape what happens next.
Now for UUMV, but other than that, no other criminal history.
All right, so Ms. Payne, I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You are ordered to pay the $500 fine as well as restitution in the amount of $4,050, and to have obviously no contact or communication with Anrith Scott. If you do everything you're supposed to on this probation, follow all of the rules and don't have any violations, pay that restitution, then this is an excellent opportunity.
The details of a probation agreement are carefully laid out, and every condition matters. From fines to restrictions, the structure is clear and strict. This is a calculated opportunity, one that can either save or ruin a future. The judge ensures the defendant fully understands the weight of this deal. Nothing is left unclear. This moment highlights how the system provides chances, but with responsibility attached. It's a crossroads between redemption and failure. The defendant now holds the outcome in their own hands. Every decision from here will count.
Not have a felony conviction on your record. A felony conviction on your record would change your life very negatively in lots of ways. And so this is a great opportunity. The other side of that opportunity, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty, so you would become a convicted felon, and you could go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? Also, I want to make sure that the restitution is paid first before that fine. Right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And so if you'll just have a seat here in the courtroom, watch for probation to call you up to her desk. She's sitting right over there, and she's going to call you up when she's ready to go over your paperwork. Okay. All right, good luck to you. Thank you.
Thanks.
You have
The judge takes a moment to clearly explain what success and failure truly mean in this situation. If everything is done right, the reward is significant, no felony record. But if anything goes wrong, the consequences are immediate and severe. This contrast creates intense pressure. It's a clear line between two very different futures. The explanation is not just legal, it's deeply personal. It shows how one path leads to opportunity, while the other leads to punishment. The choice seems simple, but execution is everything. And that's where most people fail.
Weinberg, so we probably could legitimately do it from the date of arrest. He never got out. Yeah. No, sorry. Good morning. Are you Aaron Shetley? I'm sorry, Terrell Coker. Hold on a second. Miss French on Terrell Coker.
I haven't had a chance to visit with Miss French. I've been next door. But
I'll hold the case.
Please, I'll come back.
Okay.
I want to talk to Ms. French.
All right, y'all go have a seat. Corey Richardson, Mr. Crenshaw, that's a set for a plea today.
Yeah, sure.
Are y'all doing Richardson? Good morning. You're Jason Weinberg.
Yes.
Time becomes a critical factor as a defendant asks for more of it, but the court sets clear limits. There is no room for endless delays. The judge allows only what is necessary, nothing more. This moment shows how the system values progress and accountability. Deadlines are not suggestions, they are expectations. The pressure to act quickly becomes real. Every decision must now be made with urgency. It's a reminder that justice does not wait indefinitely. And those who are unprepared may suffer the consequences.
Those type of gym pants is not appropriate for court.
He's a jump pad.
They're not?
Oh, the slacks, coach.
Okay. All right. Good. All right. So will your client waive the formal reading of the indictment?
He does.
Find you. All right, Mr. Weinberg, in clause number 25, DCCR 1479, you're charged with a state jail felony offense of engaging in organized criminal activity, and that's from September 28th of 2025. And how do you plead to that charge?
Oh,
How do you plead to that charge? Guilty or not guilty? Sorry?
plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
A more serious charge enters the courtroom, bringing a noticeable shift in tone. Organized criminal activity is not taken lightly, and the gravity of the situation is clear. The defendant pleads guilty, but that doesn't reduce the seriousness of what lies ahead. This is a moment filled with tension and uncertainty. The courtroom recognizes the weight of the offense. Even with a plea, the future remains unclear. It's a situation where consequences are inevitable. The only question left is how severe they will be.
You actually did what they charged you with.
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 5-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation, which would include having no contact or no communication with Corbin Rayleigh. Is it Alan?
Should be
Aiden Dickinson and Jaden Chandler. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion?
Instead of rushing to a decision, the judge pauses the process for a deeper evaluation. A pre-sentence report is ordered, signaling that more information is needed. This adds a layer of suspense, as the final outcome is delayed. It shows that the system doesn't always act immediately, it seeks clarity first. The defendant now waits in uncertainty. This waiting period can be more stressful than the decision itself. It's a moment where everything hangs in balance. The final judgment is coming, but not just yet.
Country, denial of naturalization under federal law.
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Weinberg's not competent?
No, Judge.
I think just based on the nature of this office, I'd like to get a pre-sentence report just to see what potential conditions what might need, because based on the age and the nature of the offense. So, Mr. Weinberg, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yes.
All right, we'll see you back at sentencing.
Thank you.
Good morning, sir. Are you Joshua Barlow?
A probation violation case brings tension back into the courtroom. The possibility of losing freedom becomes very real again. Discussions about drug tests and compliance reveal how closely actions are monitored. Even small mistakes can have serious consequences. The defendant's situation feels fragile. One wrong move could send them back into custody. The court examines everything carefully. This is where past decisions catch up with the present. It's a powerful reminder that probation is not forgiveness, it's a second chance under strict watch.
And this is a motion to revoke probation. It looks like Mr. Barlow's on probation for possession of a controlled substance, penalty group 1. What is the announcement?
Judge, Mr. Barlow did retain me to represent him over in Harris County in regards to the new law violation, and actually also partially the technicals. As part of that was about living or being in Harris County during that time of the offense. We were in court Thursday. There is a 911 recording that we will have probably either today or tomorrow that is going to say a lot before it's about whether they're going to proceed with the case over there. And also, honestly, if they're going to file new charges against the complainant. As well as I think that will also give us a lot of insight into the technical violation of his.
As the courtroom moves through multiple cases, a clear pattern emerges. Every decision carries weight, and every choice has consequences. Some are given opportunities, others face delays, and a few stand on the edge of serious punishment. The final message is simple but powerful: respect the law, or face what comes next. This is not just about crime, it's about responsibility and change. Every person here is given a chance, but not everyone will keep it. And that's what makes this environment so intense and real. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
Because of the information that would have been given on transcript over the video. So I'm just asking for a short time so we can listen to that. To that.
And as far as everything going okay right now on probation? Okay. All right. So we'll just do a normal reset so you can get all that information, get it to Ms. Malfino, and then we'll see where we are on that next court date.
Judge, in light of the violation alleged in Count 6, which is the positive UA on March 4th of 25 and April 8th of 25 for marijuana, he does not currently have a drug patch. I'm assuming from Officer Kitchens that he has no UA violations during the pendency.
I gave him a drug test 310 this month, anticipating his court appearance, and he tested negative.
Okay. Okay. Obviously, if there's any issues, just let me know, or we can get that drug patch ordered.
The courtroom session begins in a calm and procedural manner. A defendant is identified, and the charges are read without urgency. At first glance, it seems like a routine start to a normal day. There is no visible tension yet, only structure and order. But even in this calm, the system is already in motion. Every step is precise and follows a strict process. This moment sets the foundation for everything that follows. It shows how even simple cases begin with discipline.
Too. All right.
Judge, also, Mr. Barlow did let me know that he does have he sent me with confirmation. He has a job interview tomorrow at 10:30.
Okay.
So we just wanted to make sure you all have that because he is, of course, on restrictions with the GPS monitoring.
Okay, just send that over in a memo if you would, so that I know, make sure you talk to probation so they know where you're going as well. Okay? So did we start something and then not do it last on the 2nd? Were we here March 2nd? I show that I have a revised indictment already. I don't recall that. Okay. See, I made a note on it. Oh, we must have been that.
A request for additional time is presented to the judge. The tone remains respectful and controlled throughout the exchange. The judge listens carefully before granting the request. This shows that the system allows preparation when necessary. However, it is clear that this flexibility has limits. Time is given, but it is always monitored and structured. This moment reflects balance between fairness and control. Even small decisions like this carry importance.
Oh, yes. The heading.
Yes.
Okay. Correct. So, Ms. Jackson, in cause number 25 DCCR 0903, you're charged with the state jail felony offense of abandoning or endangering a child from May 26th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be
The focus shifts as a plea deal is introduced to the defendant. This offer represents a possible way to avoid harsher consequences. The judge ensures that every detail is explained clearly. It is a moment where opportunity and risk stand side by side. The defendant is given a choice that will shape everything ahead. This is not just legal procedure, it is a life decision. The room feels more tense as the importance becomes clear. Everyone is waiting to see what choice will be made.
the rules and conditions of probation. And also there's part of the agreement is that you would not request early termination from probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No, please.
It's admitted. Is there any evidence that Ms. Jackson is not competent?
No, please.
Right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea.
Yes.
Find sufficient evidence to find you guilty. However, I'm going to reset your case. I'd like to get a pre-sentence report on it. That'll just give me more information about you and your case, and we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation. She's sitting at that desk right over there.
Yes.
And then we'll see you back at sentencing. Okay. All right. Thank you.
Thank you.
The defendant chooses to reject the plea deal. This decision instantly raises the stakes of the case. Instead of certainty, the path now leads to trial. The judge makes sure the defendant understands the risk involved. There is no turning back once this decision is locked in. This is a bold move that could have serious consequences. The tension in the courtroom becomes more noticeable. A single choice has now changed the entire direction of the case.
Your Candy Baraka.
Yes, Your Honor.
And Ms. Baraka, you had filed a petition for expunction. Sorry.
Oh, it's okay.
You had filed a petition for expunction in two cases.
Yes.
One was M241026, which was a failure to identify. And then the other was 23 CCCR 2497, which was a theft of property case. We called your case earlier, but
Sorry, Your Honor. I
okay.
flew in from Los Angeles.
I'm sorry.
I flew in from Los Angeles.
Okay.
I was in the hallway. Sorry.
So the state's position, and I already made an order in your case,
Yes.
and also the city of Beaumont was here as well, with the opposition. And the opposition by both of them is
A medical concern is brought forward as a reason for delay. This introduces a human element into an otherwise structured process. It reminds everyone that real lives and struggles are involved. The request seeks understanding from the court. There is a brief moment where emotion enters the room. However, the legal process must still continue forward. This creates a subtle conflict between empathy and duty. It is a reminder that the system cannot stop entirely.
failure to identify case,
Which
which
is-
is, hold on, don't
Right.
talk over me, which is M241026. They did not have opposition in the theft of property case. I have agreed and ordered the expunction in the theft case. However, because you pled guilty or no contest in the failure to identify case and received a probation, you're not eligible for an expunction in that case. If it was a deferred probation, you may have some rights to what's called a non-disclosure. If you finish a deferred probation, as long as there's not conviction. So you'll have to check into that. But, and it's not quite as good, I guess, as an expunction, but it is something if it was a deferred probation and if you satisfactorily completed it. So you can look into a non-disclosure for that one.
Okay.
The judge responds with calm but firm authority. While acknowledging the concern, the case is not paused indefinitely. This reinforces that the court operates within strict limits. Delays are allowed, but only to a certain extent. The system must continue moving regardless of circumstances. This moment shows the balance between compassion and discipline. The decision is clear and leaves little room for argument. The process moves forward without hesitation.
Sign it, or I am going to sign the order for the theft,
Yeah,
but not the other one.
I'm fine. I just thought that because it was maybe, I think 20 years ago.
Yeah,
It was
unfortunately, The
But
age doesn't
I'm
matter.
glad you told me how I can go about it.
Yeah, they're required by law to check everyone that comes through, and if you're not eligible, you're not eligible.
Okay.
But you can look at that non-disclosure for the failure to.
And I appreciate you, Raquel.
Yes,
Have a
ma'am.
blessed day.
Ma'am,
Your
did you just call me by my first name?
Judge.
We don't know each other, do we?
Fine. No, man. But I
Okay.
do appreciate you taking.
Okay, you're free to go.
Have a blessed day.
Good morning. Are you Maria Garza? And this is 25 DCCR 1008. Ms. Garza is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, we're asking for at least 30-day reset, so Ms. Malpino can send the victim a subpoena.
A much more serious case is introduced, shifting the tone instantly. The nature of the charge brings a heavier atmosphere into the room. This is no longer routine, it carries deeper consequences. Everyone present understands the gravity of the situation. The defendant stands in a moment of accountability. There is a noticeable change in how the courtroom feels. The seriousness of the charge demands full attention. This marks a turning point in the session.
Hearing.
Okay.
That's correct, Judge. I will send a subpoena and a letter, both in English and in Spanish, based on the information received from Mr. Rojas today.
Okay.
Ready to endorse.
All right. We'll just do a normal reset to give you time to get that taken care of. And Ms. Garza, stay in touch with Mr. Rojas and your bondsman. They'll let you know when to be back. Okay. You're free to go.
Thank you so much.
And you have Whitley Shepard. Good morning, ma'am. Are you Whitley Shepard?
Yes, ma'am.
And Ms. Shepard, in cause number 25 DCCR 1146, is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, Ms. Shepard and I have previously talked about her case early on. I just got an offer last week and I've talked with her a little bit this morning. I think I need more time to explain to her what it all entails.
Yes, sir. And so, Ms. Shepard, I'm going to do a normal reset in about 30 days. Make sure you call and make an appointment soon to go visit with Mr. Rojas. So you'll go over everything, all the discovery, what your options are, and things like that. And then we'll.
The defendant enters a guilty plea without resistance. This removes any uncertainty about what has occurred. The focus now shifts entirely to consequences. There is no argument or delay, just acceptance. It is a moment that carries emotional weight. The courtroom remains quiet as the plea is confirmed. This step finalizes one part of the process. What follows will determine the future ahead.
Next court date, okay? Answer out loud, please.
Yes, ma'am.
Thank you. You're free to go.
We're talking about Mr. Valentino, Judge?
Yeah.
Yeah.
Good morning, sir. Are you John Sharp?
Yes, ma'am.
Judge, with the court's permission, we're going to proceed on a lesser included Class A terroristic threat public servant.
Yes, ma'am. Will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Sharp, in cause number 25, DCCR 1476, the state has elected to proceed on the lesser included offense of a Class A misdemeanor terroristic threat, and that's from September 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
It's fine.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1.
The judge carefully reviews the plea and supporting details. This ensures that everything has been handled correctly. Fairness remains a priority, even in serious cases. Every step must follow proper legal procedure. There is no rushing toward a decision. The process is deliberate and controlled. This reinforces trust in the system's structure. Accuracy matters before any outcome is given.
Did you go over them with Mr. Rennick?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
There is not, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and successfully complete your probation, then this is a great opportunity because you don't have the conviction on your record.
Yes,
and at the end of the probation,
Instead of immediate prison time, probation is granted. This introduces the idea of a second chance. However, it is not freedom, it is controlled responsibility. Strict conditions are placed on the defendant. Every action moving forward will be monitored. This decision offers an opportunity to rebuild. But it also comes with significant pressure. The future now depends entirely on compliance.
case is dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing, number one, the conviction, and two, a sentence in our county jail for up to 1 year. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right over there. She's going to call you up when she's ready to go over your paperwork.
Yes, ma'am.
All right. Good luck to you, sir.
And Judge, I failed to bring the certificate for discovery up, so I'm gonna bring that right.
Okay, if you'll go ahead and get the one
Yeah,
signed,
right.
please, and then just have email the attachment to Ms. Holmes, please.
See, Ms. Molfino, this one's yours.
Good morning, sir.
The judge outlines the rules of probation in detail. Each condition is explained to avoid misunderstanding. There is no ambiguity in what is expected. The defendant is made fully aware of the responsibilities ahead. This clarity removes any excuse for future violations. The tone remains serious and direct. It emphasizes that this opportunity must be respected. Every rule carries weight moving forward.
Macon, will your client waive the formal reading of the indictment?
Yes, sir.
Mr. Flores, in clause number 25 DCCR 1231, you're charged with the state jail felony offense of abandoning or injuring a child from July 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Absolutely.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and
A strong warning follows immediately after the conditions. The judge makes it clear that failure will have consequences. There is no leniency if rules are broken. This transforms the opportunity into a high-stakes situation. The defendant must now act with discipline at all times. Freedom is conditional and fragile. One mistake could undo everything. The seriousness of this moment cannot be ignored.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
I have no objection to one, Your Honor.
It's admitted. Is there any evidence that Mr. Flores is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a free sentence report. It'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there behind you. Judge, I need your discovery certification as well.
I handed it to you.
I asked that
Another defendant approaches with a different attitude. There is no hesitation in their response. A guilty plea is entered quickly and directly. This shows acceptance of the situation. There is no attempt to delay or challenge the charge. The tone here feels more resolved than conflicted. It reflects a different kind of decision-making. The process continues without resistance.
this assessment be done with the PSI as well. This was the DWI child passenger that was re-indicted.
Yes, ma'am. If you'll make sure and get a substance abuse assessment as well. All right, and I'll get that. You can stop. Go ahead and stop at the probation, and I'll take care of that. Good morning. Good morning.
Good morning.
And sir, you're going to translate
Yes,
today.
ma'am.
What is your name for the record? Antonio Aguilar.
Yes, ma'am.
Would you please raise your hand, Mr. Aguilar? Do you swear or affirm that you're going to truthfully and accurately translate from English to Spanish and Spanish to English to help you God?
Yes, ma'am.
Thank you. And are you Juan Martinez Rodriguez?
Yep.
So you've got to translate everything I say and then everything he says back.
Yes, Antonio Martinez. Yes, yes.
And will your client waive the formal reading of the indictment?
Yes, sir.
Mr. Rodriguez, in cause number 25 DCCR 0017,
And that's what's the number?
25
25.
DCCR
This is 0017.
0017, you're charged with theft of property, a third-degree felony.
The judge confirms that the plea is voluntary and informed. This step is critical to ensure fairness. No one should plead guilty without full understanding. The court takes time to verify every detail. This protects both the defendant and the system. There is careful attention to accuracy. The process remains structured and precise. Every confirmation matters before moving forward.
From September 12th of 2024. And how do you plead to that charge?
Como culpa de ese cargo. Inocencia, no contexto culpable. Pues nos sentimos más, era una trocamiento. Just not guilty, wasn't his truck.
Your Honor, I would ask we give it a few minutes.
I'll hold the case. This is, yeah, it's French. Good morning. Are you Daylene Rodriguez?
Yes, ma'am.
And this is 25 DCCR 0856. Okay. Ms. Rodriguez is charged.
As the final cases unfold, the courtroom settles into a steady rhythm. Each defendant steps forward to face their own moment of truth. Charges are presented, decisions are made, and consequences follow. The repetition does not reduce the importance of each case. Every situation carries its own weight and impact. The system remains consistent, disciplined, and controlled. What stands out most is how every choice matters deeply. In the end, this courtroom is not just about punishment, it is about responsibility, consequences, and the direction each person chooses to take in life. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
Assault. And Mr. Kelly, what is the announcement?
Yes, Judge, Ms. French has advised me that she'd like some time to speak with the complaining defendants.
Okay, so you just recently got this one. Okay, I'll do
Yes, Your Honor.
a reset for you on that one. And then once that takes place, obviously you guys need to get together. You've been on it for a little bit, Mr. Kelly. So let's get an announcement at that next court date.
Thanks, Judge.
All right, thank you. You stay in touch with Mr. Kelly. Once Ms. French talks to him, y'all have some more information. Mr. Jeffries, do you have John Pugh?
Yes.
Morning. How are you?
Doing it now.
Good. Good morning, sir. You're John Pugh.
Yes.
This is 25 DCCR 1470. Mr. Pugh is charged with aggravated assault with a deadly weapon. And what is the announcement?
We've just received an offer, Your Honor. We'd like one more setting to be able to discuss that, go forward before we decide to move to trial.
Any issues? No. Did you? You okay?
Okay.
Yeah, sorry. Excuse me. No, I would just ask that Mr. Jeffries please make a request for the video, would you? And
Okay,
be sure
there's still some
to
media.
with the paper trail listening.
Yeah, make sure you get that request in today for the media so that you guys can go over that as well before that next court date. Stay in touch with Mr. Jeffries. Once he receives everything from the assistant district attorney, you'll be able to go over that. We'll get an announcement at the next court date. And if you've already done that, then everybody just make sure where it is in the process.
Okay.
All right. Thank you, sir. You're free to go.
Thank you.
Thank you.